life. On any of these grounds, it was thought that there was now a majority by 1992 to overrule Roe v. Wade. But it was not to be. In the Casey case, you had this fascinating phenomena of three judges of the court, Justices O'Connor, Souter, and Kennedy, writing a separate opinion that really became the main opinion that now governs abortion. These three justices linked up their votes with two more liberal justices who would have upheld Roe v. Wade as decided in Roe v. Wade. But together, these five stood against four who would have overruled Roe v. Wade. So, the essence of Roe v. Wade remained intact, but Casey did change things somewhat, as I will now tell you. First, in terms of remaining intact, the plurality, this three-judge plurality of O'Connor, Souter, and Kennedy, said, we affirm the essential ruling, the essential holding of Roe v. Wade. That is to say, we acknowledge that it is legitimate for the court to identify and to substantially protect personal individual liberties under substantive due process. So they accepted the venture. Further, they said among those liberties is the right to an abortion, the right for a woman to retain ultimate control over her destiny and her body, which were the issues at stake in terms of the question of abortion. What the court did, however, is it gave greater latitude to the states to regulate, even though it maintained the general protection of the right against most state interference. The dividing line for the court remained viability, and the rules shaped by the court in the Casey case came to this. Prior to viability, the court said, or this plurality opinion, which is really the center of gravity now on this issue, the plurality said, a state may not impose undue burdens on the woman's right to have an abortion. And by an undue burden, the court meant any state regulation that had the purpose or effect of placing an obstacle, a substantial obstacle, in the path of a woman seeking an abortion. Now, after viability, just as with Roe v. Wade, the state could regulate, in fact, it could completely prohibit abortion, except where the life or serious health interests of the mother were implicated. So under Casey, viability remained an essential feature, an essential dividing line of the state's ability to regulate. However, greater latitude to regulate was permitted in the pre-viability period. But note, it's just a little. It's not a lot of a change from Roe v. Wade itself. So in terms of pre-viability abortions, a woman has a fundamental right to make that decision on her own, but she's not protected against any and all regulation by the state, but only those regulations that present an undue burden or a substantial obstacle. For example, under this test, the court upheld the requirement that a woman give written and informed consent before the procedure. It upheld a 24-hour waiting period between the time the woman elects the procedure and actually has it. And from prior cases, it upheld tests to determine if the fetus was viable. It upheld the requirement that the physician give the woman truthful information about the abortion procedure. These things were okay now, because although they made it somewhat more difficult to get an abortion, perhaps, and although they may have made it somewhat more expensive, they were not substantial obstacles placed in the path of the woman. So, Casey somewhat expanded the ability of the states to regulate abortion, though again, they are not allowed to prohibit it or place substantial obstacles in the way of the woman pre-viability. Now, that having been said, you should note that state and local governments do have greater latitude to regulate in a number of other aspects of abortion matters. First, they have greater latitude to regulate when they're dealing with minors. With respect to minors, the court has said, for example, that you can require parental notification. You can even require parental consent if there's something in the law known as a judicial bypass available to the minor. And of course, we're talking here about unemancipated minors, those living under the home of a guardian or a parent. And by a judicial bypass, I mean some procedure in the law whereby the minor can go into a court and say, I haven't notified, or I haven't gotten consent, whatever the law says, but I don't have to, because there are really good reasons why I shouldn't, and it's in my best interest, in the best interest of the minor, of me, to avoid these requirements and allow the abortion to take place. Moreover, as part of a general orientation about constitutional rights, you should realize that the government has no affirmative constitutional duties to help people, and this relates to another aspect of the abortion matter. That is to say, the government doesn't have to fund or finance abortions. Even if it has laws where it's funding or paying for all other medically necessary health procedures, and even if the abortion procedure is a medically necessary procedure, the government can say, we're not going to give you money for this. And that has been upheld. It's neither a violation of substantive due process nor equal protection of the law. And this has been summed up by saying, just as a person has a right to travel, that may be fundamental. In the same way the government doesn't have to give you bus money, it doesn't have to pay for your abortions. Moreover, the court has held that states can prohibit public employees from performing abortions, and they can prevent persons from using public facilities to perform abortions. Finally, it even went so far in the case of Rust versus Sullivan to say that the government can have a rule that eliminates any abortion information at federally funded clinics. Now, as it happens, the Clinton administration has changed this rule as a matter of policy. But constitutionally, the government could have such a ban on information in federally funded clinics. So, with Casey, there's greater latitude to regulate, and there are these opportunities for the government to resist support of abortion, if you will. But in general, the essence of Roe versus Wade, and by the essence I mean the idea that there is a fundamental right here, it is entitled to special protection under substantive due process in the pre-viability period, has been upheld. Now, as you know, if you think about the list of rights that I've mentioned, this is not really an extensive list of unwritten fundamental rights, because in general the court is very reluctant to set itself up against legislative choices, and substantive due process does put it on thin ice because it's reading in rights, it's implying rights that are not readily found certainly in the text or necessarily in the history of the text. And so be careful in this area. It's not an open-ended set of rights, to be sure. And to underline the fact that there are limits, consider the case of Bowers versus Hardwick. The court said in Bowers versus Hardwick, in upholding a Georgia statute that made it a crime to commit sodomy, the court upheld it. It says that there is no general right of personal liberty. It said that there's no fundamental right for adults to engage in private consensual sexual behavior. There is no such right, and the court in dicta said laws that ban adultery or incest or fornication or sodomy are not to be judged under any special compelling interest test. They are to be judged under the rational basis test. They're not specially protected rights. And the court upheld the sodomy statute in Bowers versus Hardwick. Remember, if it's not a fundamental personal right under substantive due process, you apply rational basis, as the court did in that case, and it said in Bowers that there was a rational basis based upon the moral judgments of the majority to ban and make criminal sodomy. Okay, that completes our look at substantive due process. Now I'd like to turn to the final aspect of due process of law, namely procedural due process. As the name suggests, procedural due process deals with procedures, or how the government acts. Now, the Due Process Clause says, I'm quoting from the 14th Amendment, nor shall any state deprive any person of life, liberty, or property without due process of law. Now, procedural due process doesn't create interest in life, liberty, or property. It simply provides that if the government deprives you of an already acquired life, liberty, or property interest, then it must use certain procedures, certain processes to ensure that it's acting fairly and accurately. And typically, as we'll discuss, fair procedures means minimally a fair notice and an opportunity to be heard, usually the opportunity to be heard should come before the deputy